Good morning, and thank you so much for your interest in our training series on research using protected data. Just very briefly, a little bit about the Institutional Review Board, the entity I'm representing in this training. The Institutional Review Board is an independent committee charged with the ethical review, revision, and approval of research involving human participants. Members of USU's Institutional Review Board further the university's research mission by prospectively reviewing proposed research involving human participants to ensure the protection of those research participants. We're also looking to ensure justice, beneficence, and respect for persons in all of USU's research involving human participants. We work to create a culture of ethical concern and prioritization of research participant interests. And of course, we engage in compliance efforts with international, indigenous, sovereign, federal, state, local, and university requirements for conducting research with human participants. The Institutional Review Board is situated within the Human Research Protection Program, which is a broad structure where everyone is working together to ensure the protection of human research participants. So that includes the IRB, it includes the Human Research Protections Office. We coordinate with lots of other entities, including research participants themselves. And we work to implement protections as a board in the research that gets proposed, but ultimately it is you, the researchers, who ensure that all of these protections are in place and are responsible for the experience that research participants are going to be having in your project. So that's a little bit about the IRB and the Human Research Protection Program, or HRPP. Let's move on to today's session. Today we're talking about research with protected data. And so we're going to identify when HIPAA, FERPA, or the PPRA might apply to your project, understand what those are and what is not permitted without authorization and consent under those regulatory structures, anticipate compliance issues early in our study design process, and come away ready to design a research project that emphasizes participant trust and participant privacy. It's important, I think, to start with the definition of a human subject. In part because quite a bit of work under these regulatory structures can include absolutely no interaction with a living person. And so understanding the context in which the protected data you might be working with could constitute research is important. So research means a systematic investigation, including research development, testing, and evaluation that's designed to develop or contribute to generalizable knowledge. The systematic investigation part is a very important part of our determination on whether a project constitutes research. And so here's a little bit of the factors that we look at when we're making a determination about whether any given project is research, looking specifically at systematic investigation. And then next, we have those aspects of generalizable knowledge that we're looking for. And so for a project to be considered research, it must have both of those important elements, systematic investigation and generalizable knowledge. And so again, this is important because we need to identify research projects so that we can identify where those research projects are subject to HIPAA, FERPA, the PPRA. The next piece and the trickier one is, well, trickier in terms of whether there's a human subject involved in your existing data research anyway, is human subject. And a human subject is a living individual about whom an investigator, whether that's a professional investigator or a student, conducting research, obtains information or biospecimens through intervention or interaction, or does any of those things with identifiable private information or specimens. So obtains, uses, studies, analyzes, or generates. And here I've just included some other definitions of some of those key terms for that definition of human subject. And so here we have some information about what constitutes an intervention, what constitutes an interaction, what means, or what private information means, and what identifiable private information means. And finally, identifiable biospecimens. For the pieces here where it's important for you to identify whether the data that you're working with are a human subject, we're really looking at these aspects of the common rule definition of a human subject. So this is the case where you're not going to interact with anyone and you're not going to obtain consent for information. You still may have a human subject if the information that you're using is identifiable private information. And so those are the definitions that are most relevant for you to make a determination. But you do not need to do that. We have a non-human subjects research determination process that is really rapid and very short for you to complete. And we'll include that in some resources when we post the recording of this webinar. Okay, let's jump into HIPAA. The Health Insurance Portability and Accountability Act is what we call HIPAA. HIPAA is a privacy regulation, and it governs protected health information, whether that information is used in research or not. So it's important to note this is not a research-specific regulation. It applies to certain types of information regardless of what you're doing with it or how you come to access it. HIPAA governs protected health information, which we'll define briefly on the next slide. It does not cover information that is voluntarily disclosed directly by the participant about whom the information pertains. If someone wants to give me a questionnaire about my very most sensitive health information, if I voluntarily respond to that questionnaire, no matter the health information included, that information comes directly from me, HIPAA does not apply. However, if that information is coming from a covered entity, which we'll also talk about in a moment, then HIPAA applies, and all of the pieces I'm going to be talking about here are things that researchers need to consider before they can use any of that information. Other things to be aware of, it doesn't cover all types of health information, as I've just said. Information I share directly with a researcher is not covered by HIPAA. It is also not the only health-related privacy regulation. It is the most common one, so it is the one we will visit about today. But there are many, and it's important for researchers who are working with health information to understand the regulatory landscape around any information they might be seeking to use. Okay, HIPAA governs protected health information. What is protected health information? It is information that is individually identifiable health information in any form. That can be oral, it can be written, handwritten, it can be electronic, it can be labels on a tube. It is any health information in any form if those data are held or obtained by a covered entity or its business associate. And we'll talk about covered entity on the next slide. Health information is any information, including demographic data, that relates to an individual's past, present, or future mental health or condition, the provision of healthcare to that individual, or the past, present, or future payment for the provision of healthcare to that individual. The covered entity piece is also very important. So again, I can share my health information and HIPAA does not apply. But if you were to go to one of my medical providers to obtain my health information, that medical provider is almost certainly a covered entity. Covered entities, though, can be a lot of things. They are primarily in the research context, healthcare providers. Any healthcare provider who electronically transmits health information. And it's almost impossible not to do that these days. They can also be health plans, like if we're at Utah State University and we have Regents. Regents is a covered entity, so they also cannot release my health information without being subject to HIPAA. Prescription drug insurers, health maintenance organizations, long-term care insurers. So the Hartford, who provides short-term disability insurance at Utah State University, also a covered entity. And any of those entities' business associates. So a business associate is any entity that performs certain services for a covered entity. So say my doctor's office doesn't have the capacity to do their own billing. They contract with somebody to do billing. If that entity is receiving or transmitting any electronic information about identifiable health information, they are a covered entity under HIPAA. It's really important to be able to identify a covered entity in the research context. There are a lot of things that don't necessarily look like covered entities on the surface, but are, and it's really critical that you as a researcher help them to comply with HIPAA when you're working with them for research data or even to contact potential participants. So a lot of employment services and employment training firms, they're billing Medicaid for their services that they're providing. That's going to be a covered entity. Any local agency that receives funding from the Utah Department of Health, covered entity. And so it's a really broad umbrella. And so it's important to come back and think about, is it health information? And does this entity transmit that information electronically? Rather than being stuck in, oh, that's a doctor's office or, oh, that's health insurance. Looking at what they're doing and the data that they maintain is a critical piece of ensuring HIPAA compliance. So, if you're going to use protected health information, so health information that is identifiable that comes from a covered entity, how can you do that? In one of these 5 ways. And we're going to go over each of these on the subsequent slides. An authorization directly from the person who the information is about or their legally authorized representative. A waiver or alteration of authorization, which looks a lot like waivers and alterations of informed consent in the IRB context. De-identified data, limited data sets, and activities preparatory to research. So let's jump into those. The first and most widely used option is an authorization for the use of protected health information. So that is where I, researcher, am going to ask you, client or patient, for your permission to use your protected health information in my research. An authorization is that written permission, and it must be authenticated. So it's not important, it's important that it be written and documented somewhere, but also, especially in an online context, authenticated. And that means that you must have a way already of knowing who the person is and having a way to verify, if you're doing this online, that the person signing is indeed the person who has the ability to give that information away. For those of you who were here in 2020 and 2021, when you used the COVID testing center, when you logged into Aggie Health, you had to input your A number and your password like you usually do. But then you had to do a thing you don't typically have to do at Utah State University, which was to enter your date of birth. That was Utah State University's way of authenticating your identity so that you could consent to the testing procedures. Something like that must be in place if you're going to do an electronic version of an authorization as well. And so that might require you to work with the healthcare provider to get information that allows you to authenticate that individual if you're going for an electronic version of an authorization. An authorization also specifically identifies the protected health information that is sought. It identifies who will access it, how it will be used, and for how long. An authorization can be combined with your informed consent document, but it is not a substitute and it's not the same as an informed consent document. So we do allow you to combine those. Some entities do not. But it's important to note that the elements of informed consent still must be presented and the elements of an authorization still must be presented. Finally, just something to note, we make a template available of an authorization for the use of protected health information on our website. That again will be posted with these slides as a direct link to that resource so that you can access it whenever you're thinking about performing research with protected health information. Some practical tips regarding authorizations. It's important that you work early with the covered entity who holds that information. Some entities might have their own required authorization templates. So ours meets the requirements for HIPAA, but Intermountain Health, for example, has their own authorization that they would prefer researchers use if they're going to be contacting Intermountain clients. And so even though our authorization is legally sufficient, they will want you to use theirs. So it's important to get in touch early with that covered entity to see what the requirements are for obtaining authorizations for the use of protected health information from their clients or their participants or their patients, however they refer to them. It's also important to note that outside of the state of Utah, many states have their own required authorization elements, so on top of those required by HIPAA. And so if you were just to present somebody in the state of New York with our authorization, it would not be legally sufficient for the place where you'd be getting the information. So again, work with that covered entity early. And then finally, consider the use of an alteration for initially contacting a participant to ask for the use of their protected health information. What's an alteration, you ask? Waivers and alterations allow researchers to access protected health information under certain conditions without prior permission from the individual. And so we can grant that under certain conditions. These conditions are non-negotiable. Researchers must demonstrate that they can meet all of these conditions in order for an IRB or a privacy board to grant a waiver or authorization or alteration of authorization. Um, and so I won't dive into all of these in great detail. I will note that they look a lot like the waiver requirements for informed consent. Um, and so that is part of why, in many cases, IRBs are also the ones to issue these waivers. Technically, a waiver can only be issued by a privacy board that has the authority to review the release of that protected health information. So, Utah State University's privacy board is also its institutional review board. However, if you're working with an outside entity that focuses exclusively on health care, or you're working with an independent provider, they may not have a privacy board. They can accept the determination of USU's privacy board, its institutional review board, but they don't have to. Larger health organizations, I'll use Intermountain as an example again, has their own privacy board, and they are going to want those determinations to come from their privacy board. So it's really important that you work again early with that covered entity to determine how best and what mechanisms you need to adhere to in order to use protected health information that is in their care and control. Um, Back to waivers and alterations, sort of writ large. When a researcher or anyone really is accessing protected health information without specific authorization from the client or patient, the covered entity has to retain a record that they use whenever a person comes asking whether their health information has been shared. So perhaps you don't know this. You can go to your healthcare provider and ask for something called an accounting of disclosure. And that is a record that your healthcare provider, your covered entity, must maintain anytime they release your protected health information without your consent. And so for researchers who are working with smaller covered entities, it would be wise to help that covered entity to develop a system for maintaining those accountings of disclosures. They may not be prepared to do it otherwise. They may not have the infrastructure for thinking about the release of protected health information regularly. And so as a researcher, it would be kind of you to help them with HIPAA compliance so that in assisting you with your research, your covered entity research partner doesn't get into hot water. Anyway, so anytime you're requesting a waiver or an alteration, these are the criteria. I'll point out a couple of really important ones. The last one, the information sought must be the minimum necessary information to complete the research. Again, only under a waiver or an alteration. But the idea here is that since you're not getting permission, you should have access to no more than you need to address your research question. Another requirement is that you do have a plan to destroy the identifiers at the earliest opportunity, unless there's a health-related justification for maintaining that. So, for example, as I put in the slide, the information that you're going to get combined with some other data that you have in your research project might positively inform a person's treatment plan. In that case, we wouldn't want you to destroy identifiers. We want you to share that with the covered entity if it results in better care for the person whose information they released to you. Some practical tips about waivers and alterations. Again, working early with that entity that will release the protected health information is critically important because they may have their own privacy board, they may have their own standards, they might require more than HIPAA requires for the release of that information, in which case our determinations aren't going to mean anything to that entity. Again, if the organization is a smaller one, prepare to help them with HIPAA compliance. That AOD's term there stands for the accounting of disclosures that we talked about on the last slide. And then finally, and here's the thing I referenced in the previous authorization section, you can seek an alteration for contact information. It's also referred to as a partial waiver. And that helps you to recruit people to your study using the authorization process. So the alteration here is that you're going to receive some contact information from the covered entity. You're going to use that contact information and perhaps even information to authenticate that individual's identity in order to ask people whether you can then use their full PHI in your project. If no, you need to delete it at the earliest opportunity. So if they don't respond, for example. But if yes, then in your authorization, you will identify the PHI you've already accessed along with the PHI you now wish to access. And all of that becomes covered by the authorization itself. So the alteration is just sort of adjusting the timing of when that authorization would occur. So rather than it occurring before you access all PHI, it occurs before you access some PHI. De-identification is the third way that researchers can access protected health information. And that does not mean what we typically think it means in terms of like standard de-identification processes for research that isn't using protected information. It can only be done under HIPAA in one of two ways: de-identification by a qualified statistician, or the removal of all 18 HIPAA identifiers, which we have a guidance document on that will be posted to the resources section of where we post this training later. Um, so all 18 of those identifiers and those about their relatives, household members, and their employer. Um, and finally, the information left, even after the removal of those identifiers, cannot permit the covered entity to have actual knowledge that the remaining information can be used to identify the individual. So if you, for example, are the healthcare provider and you only see four clients and you want to use your client's protected health information, it is unlikely that you can use the de-identification route because it's unlikely that the information would not be able to be actually known by you to belong to a person. And so you'd want to do the de-identification by a qualified statistician, or ideally, if you're working with four clients, you'd obtain an authorization for the use of their protected health information. Limited data sets are the next way. This is a commonly sort of misunderstood approach. A limited data set is a term of art. It doesn't just mean you're receiving limited data. It carries certain requirements about what can and cannot be shared. It requires the use of a data use agreement that is executed by the appropriate sponsored programs representative here at Utah State University, as well as the appropriate representative at the covered entity. It requires secure methods of transferring that information, and it would require that the data you receive exclude most HIPAA identifiers, but it allows for the retention of some dates and geographic information. It is indeed very limited. And I don't know that I've ever seen a research project here at Utah State able to be completed using the data that are allowed to be transferred via a limited data set, but that information is available. And again, the identifiers that can stay and go will be in that guidance document that we post. This is just a broad overview of some of the ways you can access PHI for research. Activities preparatory to research is the last item under how you can access PHI for research purposes. This allows researchers to access protected health information only to prepare a study. So you're thinking you might want to do research involving a particular diagnosis among a particular population, and you have access to one clinic's records. You are permitted, if the clinic allows you, under HIPAA, you are permitted to access that information to determine whether there are sufficient numbers of those people for you to conduct your research study. No data may leave the covered entity, leave their record systems even. So for example, if you're the clinician, you cannot copy those over into a box file, nor can they be analyzed beyond ascertaining the feasibility of conducting the study. And you cannot contact individuals as a result of that review. Again, you'd more be seeking an alteration of the authorization for the use of protected health information if you wanted to be able to contact individuals to recruit them into your study or even ask them if they'd be interested in such a study. So this is really like, can I perform this research with the data available to me? Yes, no, and then it's time to move on to one of the other methods we've just talked about. That is it for HIPAA. Let's talk now about FERPA, the Family Educational Rights and Privacy Act. FERPA is an educational privacy records law. And so it governs identifiable education records. It does not cover information voluntarily disclosed directly by the participant about whom the information pertains. So again, if I want to voluntarily share with somebody what my GPA was in law school, I can do that, and it's not covered by FERPA. But if they wanted to go to my law school, go Knowles, Florida State, and get my GPA, then they would need to comply with FERPA's requirements. So that, again, just like HIPAA, that distinction of it matters where you're getting the information. It does not cover all types of education records, and it is not the only education-related privacy regulation. So just like there are other regulations that govern specific types of health information besides FERPA or HIPAA, there are others besides FERPA that govern education information. So what does FERPA cover? Here we say identifiable education records. What are those items? It is a record that is directly related to a student, maintained by the institution or a party acting on its behalf. And the identity of the student can be ascertained with reasonable certainty. So again, that doesn't require direct identifiers. It can include indirect identifiers. Um, Here are some examples of common identifiable education records. Grades about a student, transcripts about a student, their course enrollments, advising notes, disability accommodations, things like that. It does not include notes made for the sole reference and in the sole possession of the maker, law enforcement unit records, and employment records unrelated to a student status. For example, we employ two students in our office. They happen to be students. They are not employed here because they are students. And so any records related to like their attendance at work or the work that they've performed is not a FERPA protected record, even though those folks are USU students. So how can you use education records in your research? 4 ways under FERPA. Permission, school official exception, de-identified data, and directory information. We'll visit about each of those in a little bit more detail. The first is permission. Just like a HIPAA authorization for the use of protected health information, FERPA calls it permission. And so that permission must be in writing. It must specify the records to be disclosed. It needs to state the purpose of the release. So using FERPA protected records in research that requires misdirection or deception would be rather difficult. And so you'll want to explore one of the other methods if that's something that's critical to your study design. And the recipient of the records must be identified. Now, that can be IRB approved study staff. It doesn't have to name each individual person. We have templates. I'll get 2 templates here actually that I'll point to. One is specifically just for the access of FERPA protected records. And then the other, the IRB makes available in its informed consent documents, all of the elements that are required for FERPA. And so unlike HIPAA, you can combine a FERPA authorization with an informed consent process because our informed consent process requires the level of detail that would be needed for a standalone valid FERPA permission process. So let's talk next about the school official exception. This exception to accessing identifiable education records can be used when the researchers are acting on behalf of the institution. They must demonstrate that it is in the student's legitimate educational interest, and they must also demonstrate that the institution retains control over the use of the data. So some practical tips for how you might implement that. We maintain a template memorandum for use between the dean's office that oversees that researcher or the data, I guess. And that agreement allows the dean's office to maintain care and control over the data. It also identifies the legitimate educational interest that's at play. And it allows the researcher to conduct educational research on sort of the dean's office's behalf. And so here, if you're using this exception, it's important to work early with your dean's office to execute those agreements and have those plans in place. You'll want to do that before you're coming to the IRB because it will impact the way we review your protocol because we have to review it under one of the paths we're about to talk about or have talked about for using identifiable education records. And so if this isn't already here, we can't assume that it will be there. So you'll work through this process before you submit to the board. And then that allows us to understand, okay, this person is using the school official exception, and that's how they're going to access this human subject's data. This process is also preferable when working with one's own students' records because it eliminates the undue influence piece of an instructor asking their own students for permission to use their records. I do just want to pause here. We have an entirely different training on our website that is dedicated to working with your own students. That training touches way more on the aspects of allowing people voluntary choice and removing opportunities for undue influence and strategies that you might use to do that. And so if you're working with your own students, I'd say it's really important to view this training and its resources alongside that other training and the resources provided for ensuring that you're working ethically and appropriately with people with whom you have a power uneven relationship. So the second to last way you can work with identifiable education records are to obtain de-identified student data. So that is identifiable education records that will be de-identified before they come to you. And so this can be used if there's no reasonable basis on which to believe the records can be re-identified. Um, and it is of limited applicability when you're working with small samples. So just like that example I gave, where if you're a clinician working with 4 clients, if you're an instructor working with 6 students, it is reasonable to believe that those records could be re-identified even if names are removed. However, we do have several pathways for access here at Utah State University. Um, that kind of splits into where you're getting the records or what they are. So the registrar's office will, subject to their ability and bandwidth, provide de-identified records to researchers where those records are under their control. So the information the registrar's office maintains are more like it's information that's not maintained in Canvas. So think attendance records, majors, overall GPAs, things like that. When you're working within a particular class environment, so think Canvas data, the Teaching and Learning Technologies group can assist with accessing that information. They have a brief form that they ask researchers to fill out. We'll again post a link to that and the resources that get posted with this training on our website. Um, and so when you fill out that form, that helps them to identify the Canvas data that will be useful for your project and then completely de-identify that for you. Just so you know, if you're working with your own students, that also often means removing you from your own Canvas course so that the institution can indeed say that there's no reasonable basis on which to believe that you could re-identify those records. But very helpful resources that allow researchers a lot of access to educational records that a lot of the institutions don't have in place to support the research aim of their mission. So we're really lucky to have that here at Utah State. The last way to access information about students is directory information. Directory information is information which an institution or school district identifies as not being a privacy violation to release. It often includes things like names, addresses and email addresses, participation in officially recognized activities in sports, and photographs. This information alone is rarely useful for a research purpose. However, it is exceptionally useful in terms of combining it with that written permission piece we talked about first. So if you can obtain a name and an email address for a parent in a K-12 research setting, for example, you can then contact that parent to ask for their permission to use FERPA protected records in your research. So this is a piece you're largely going to use in combination with other information. It's pretty rare that you would use directory information on its own for a research purpose. Some things to know about directory information. Just because it's directory information does not mean that you can use it if you have access to it. Every school district and every institution of higher education gets to say what its directory information is, and it's not the same across educational entities. And just because an entity lists something as directory information does not mean that they need to share it with you. It merely allows them to share it with you. So it's still up to them whether to release that information. As with HIPAA, many entities have their own formal request process for releasing directory information. IRB approval is often not sufficient. So it's really important to work closely with that entity to make sure that they're willing to release that information to you. Finally, teachers, instructors, classroom aides, faculty here at Utah State University are almost never the authorized individuals for sharing this type of information. A critical piece of directory information is that every family and every authorized student be able to opt out of their directory information being shared. And that opt-out piece is really critical for that entity to keep track of. And it's often used in cases where there's been a stalking incident or a sexual misconduct incident, and that student wants to be able to hide themselves from the former perpetrator. So it's critical that when you're accessing directory information, you don't just go to the teacher that you're working with and say, hey, I want this information and it's directory information, because that person often has no ability to discern whether any given student of theirs has opted out of that information being shared. You must go to the central offices that maintain that information in order to access it. So that's going to be a registrar's office, an enrollment management office, a principal's office. Those are the only spaces that maintain, on the whole, those kinds of opt-outs. And again, critically important that you comply with that. Here are the top three FERPA compliance issues that we see. Using your own students' data, absent one of the approved ways to do it listed before. Obtaining information from someone unauthorized by the institution or the district to release it, and not properly identifying a record as an education record. So hopefully after working through this training, you're prepared to avoid all of those FERPA compliance issues. The consequences of not are that a school could be subject to a lawsuit from families or students whose information are released. The federal government can fine the school or the school district for violations of FERPA. And I think something else to consider is that the reputational risk is critical. If an entity is identified as one that gives out its students' information in violation of FERPA, they're going to take a reputational hit for that. And that's certainly not something any of us want for our research partners. Finally, we're going to touch a little bit on Utah student privacy and data protection laws. It's also referred to as the Utah PPRA, even though that's not what it's called. What it's called is activities prohibited without prior written consent and validity of consent. Um, but this Utah-specific law does not protect data so much as it protects students from being asked to generate certain data on certain topics without their parents' explicit written permission. It is a more specific form of a federal law that protects much of the same data. So we're talking about the Utah specific one, but it does overlap substantially with a federal requirement that is present for any entity that receives federal dollars for education, which is almost all of them. And so something to note is that some of these topics are not in the federal PPRA. Most of them are. So you can kind of use this list to think about whether you need to approach this in this way for any student, regardless of where they're located. But this is the Utah specific version of this. So essentially, this law says that researchers must obtain written parental permission to survey any Utah pre-K to 12 student regarding any of the following. They're going to engage with any psychological or psychiatric examination, test, or treatment. That includes just using a validated measure, not for a diagnostic purpose, or any survey, analysis, or evaluation in which the purpose or effect is to cause the student to reveal information, whether identifiable or not, about the student or the student's family's list of those prohibitions. So the critical piece here is even if you're surveying or evaluating students anonymously, you will never know which students responded or what any particular student's answer was. If it is in a pre-K to 12 setting in the state of Utah, if it is on any of these topics, you must obtain written parental permission. That means no waivers of documentation of informed consent, certainly no waivers of informed consent. And it also means that you need to work through a certain process for that consent to be valid, as the title of the law states. So political affiliations, political philosophies, mental or psychological problems, sexual behavior, sexual orientation, gender identity, or attitudes, illegal, antisocial, self-incriminating, or demeaning behavior, critical appraisals of individuals with whom the student or family member has close family relationships, religious affiliations or beliefs, legally recognized privilege and analogous relationships, such as those with lawyers or clergy or medical personnel, and income except as required by law for discerning things like free and reduced lunch status. Any of those topics must have written parental permission beforehand. And what must that process look like? The parent or guardian must be given written notice of the educational or survey questions to be asked of the student. So the instrument must be shared. And it must be shared at the school. And that can be hosted on a school's website, but it must be shared at the school. There is reasonable opportunity for a parent to obtain information concerning any of those identified pieces. So, because the statute later says 2 weeks between the disclosure and giving informed consent, we also interpret 2 weeks to be that reasonable opportunity. And so, you'll have a 2 week waiting period between requesting a parent's informed consent and giving them this information, or at least telling them they have access to this information, and actually being able to collect informed consent from parents when you're surveying or evaluating on any of those topics. So that's all of the topics we're going to visit about regarding protected data in research. And the key principle that I want folks to walk away with is that as an instructor, as a clinician, you're holding in confidence someone else's data. You're holding it, but it doesn't belong to you. It's still theirs, even while it's under your care and control. It's really just like puppies. If you're watching a friend's puppy, you have to be prepared to give it back. You have to be prepared to let the friend know where it is and how it's doing. But really, I just really like puppies, and I wanted to include a picture of a puppy on my slides. So think of it more actually like a coat check. If you're the coat check, you can't wear that person's coat. You can't give their coat to someone else unless that person has the coat check claim. You can't wash their coat for them, even though it would be really nice of you to do that. You have to take really good care of it while it's with you. And if you want to borrow it, you need to ask them if you can borrow it. I think that's a good way to sort of think about protected data. You might have it, but it's not yours to use. So, some questions to ask yourself in your research planning process. What data am I using? Does it meet the definitions of any of the protected data that we've talked about earlier? Where do the data come from? Are they coming directly from the person, or are they coming from another entity who's just holding the coat for them? Who legitimately controls them? Is it yours? Is it mine? So even though you have it, whose control is it under? And most importantly, what role am I acting in when I access them? The trickiest situations that we find ourselves in compliance with these laws is people who have dual roles. So folks who are clinicians or who are instructors and are like, but I could just pull up this screen and see everything that I need to see. You're allowed to do that in that way in your role as a clinician, in your role as an instructor, as a faculty member. But when you take that hat off and you put your researcher hat on, that screen is not available to you in most cases, absent some of the exceptions we talked about, right? Like directory information, if you access it in certain spaces, or activities preparatory to research, if you're just discerning whether this project is even feasible. So really evaluate the role that you're acting in when you're looking at any of the data that you are taking care of for someone else. So I'll pause here and I want to check the Q&A for questions. And I don't see any. Fantastic. I guess I was just super clear about all manners of protected data. In that case, thank you so much for coming. If you have any follow-up questions, you can email irb@usu.edu. That's our general inbox, and it just gets triaged to the person who's most expert in being able to assist you with your query. And again, we will post the recording of this training to our website. Give us a little bit of time to caption it, but we'll put it on our website along with links to helpful resources, including data use and data sharing agreements with school districts, our authorization documents, some of those forms that you'd fill out for de-identified data, and really helpful things surrounding working with protected data. So with that, I will say thank you so much for your time, and I hope that you found this information useful as you're considering research with protected data.